Mike, check, check, check. Justin Hunt, it's all happening. Thank you to everybody rocking with the channel. Thank you to everybody subscribed through the channel, who shared a video, shared a link. It's priceless. Big thank you to everyone who's donated. If you'd like to donate, you can hit the Cash App that's right up there, or you can hit the link in the description. And big thank you to my newest members, KP Lovely and Kai. 9-second applause. Thank you. Major thank you again to everyone who's supporting this channel with a subscription and particularly a membership. That's the best way to support this channel. You get access to exclusive emojis, you get videos early and exclusive videos, and some other surprises I'm rolling out this year. There's a link in the description if you're interested in supporting this channel by becoming a member. It's all happening. Thank you guys very much. Now, big stories today. Up first, major break in Drake's defamation lawsuit against UMG. Now, as you recall, we've been covering this. It's probably been the biggest story this year. Drake filed a defamation lawsuit against his label, UMG, over Not Like Us. Additionally, he was alleging Rap Battle Rico, that UMG conspired along with iHeart and Spotify to artificially push Not Like Us as a measure to decrease Drake's value so that they can offer him less money on the re-up of his contract, which is scheduled to take place this year. Just got out the gym, just got out of the shower, and I'm here with y'all shining. So that's where we've been with this case. The last thing we've covered on this channel was UMG's motion to dismiss. It was a very hilarious read that laid out its arguments as to why the case should be dismissed. UMG also issued a motion to stay discovery. So as part of discovery, Drake's team wants access to Kendrick Lamar's contracts, access to any relevant documents that might have been said about marketing around Not Like Us. Everything that's around the Super Bowl, they want access to pay structures with the CEO of Interscope, a lot of things. And so today we have a verdict from the judge when it comes to UMG's motion to stay discovery. Okay, so court says discovery process can move forward in Drake's defamation lawsuit against UMG over Not Like Us. So this is a big win. This is a big win for Drake. Now, I'm gonna read the details of this article and we'll talk about it. But as you can see already, the judge has decided that Drake's team can move forward with discovery in this lawsuit. There's some details. We'll focus on the details in this story, but big win for Drake. All right, here's music business worldwide. At a pretrial conference this morning in New York, Judge Jeanette Vargas ruled that the discovery process in Drake's defamation lawsuit over Kendrick Lamar's Not Like Us can begin. Universal Music Group asked the U.S. federal court judge for a stay of discovery in the lawsuit on March 18th, a day after the company filed a motion to dismiss the case. As reported last week, Drake's legal team pushed back against the request to pause the evidence gathering process. Following the decision made at this morning's pretrial conference, the discovery process for both parties can now move forward. This is a key detail I'm about to read next, so pay attention to this. UMG's motion to dismiss is still pending. It's still pending with the hearing set for June 30th, right? So ultimately, UMG wants this whole thing dismissed. And the reason that they filed the motion to stay discovery because they felt like, why am I going to hand over some documents if the whole case is going to be dismissed? Now we're going to share information. That's not relevant. We'd rather have a decision made on whether or not the case will be dismissed than start the process of discovery. The judge said, no, we can start discovery. And the motion to dismiss is still pending, okay? Back to the article. In a letter to Judge Jeanette A. Vargas filed last Wednesday and obtained by Music Business Worldwide, Drake's attorney Michael J. Gottlieb argued that UMG's request to freeze discovery should be denied. UMG failed to meet its burden, Gottlieb claimed in the 4-page letter, arguing that UMG's motion to stay discovery fails on all three factors courts consider when evaluating such requests. Gottlieb's letter referenced the court's own statement that it is not the practice of this court to routinely stay discovery pending the outcome of a motion to dismiss, highlighting that such pauses are the exception rather than the rule, right? So that makes sense, right? UMG wants to stay discovery. They're like, we don't want anyone to do discovery. Why would we start discovery if we have a motion to dismiss out there? And Drake's lawyer is like, well, that's not normal practice. This court normally allows discovery to go all the way up until the motion is dismissed, right? And so that's what they were arguing in that letter. The filing arrived just one day after UMG asked the court for a stay of discovery, with the UMG attorney, Roland A. Ransom, arguing that courts in the district have emphasized that defamation defendants must be protected from unnecessary discovery to safeguard First Amendment protections. Okay. One of the things that UMG argued in their motion to dismiss, which we covered here on the channel, I'll put a link in the description. Check it out if you missed it. One of the things they argued why the case discovery should be stayed, was that it would be really expensive. It would be really expensive for them to go through that process. And apparently there's been other court cases where discovery was stayed, not necessarily in this sort of exact situation, but where discovery was stayed because it would just make for a more laborious process. So that was what UMG was arguing previously. Drake's lawsuit against UMG, filed in January, alleges that the company promoted a false and malicious narrative about Drake via the content of the lyrics, single, artwork, and music video for Not Like Us. Today's decision over discovery is the latest development in the legal fallout from one of 2024's biggest hits and high-profile rap feud. Not Like Us was released in May 2024 as part of a series of diss tracks exchanged between Drake and Lamar. We're coming up on 1 year anniversary of that awesome moment that we'll never get over. Just like COVID. Let's take a pause. UMG filed a motion to dismiss the case on March 17th, arguing that diss tracks are protected opinion that can be legally treated as a statement of fact. Drake lost a rap battle that he provoked, in which he willingly participated, the motion asserted. Instead of accepting the loss like the unbothered rap artist he often claims to be, he has sued his own record label in a misguided attempt to salve his wounds. The motion also asserted that Drake's complaint has not established actual malice on the part of UMG. Under U.S. defamation law, it's enough for a plaintiff to prove that a person or company spread false information about them. They also have to show that the false information was spread maliciously. UMG released a rap diss track conveying fiery rhetoric and insults, not factual assessments, much less false ones, UMG's motion stated. In a response to today's ruling, Drake's lead attorney, Michael Gottlieb, partner at Wilkie, Farr, and Gallagher, issued the following statement. Now it's time to see what UMG was so desperately trying to hide. So desperately trying to hide. So this is a big break. This is a big break for Drake. Big break for Drake. They can start the discovery process. Now, there's still some details here I'm going to get to in a second, but this is a very interesting juncture because this could possibly break in Drake's favor in a major way. Let's just look at the discovery process on its own, away from the fact that the motion to dismiss is still pending. They already want Kendrick's contracts. They can start looking at things, they already want compensation packages for the CEO of Interscope. This process could lead to other information that's way more damaging than whatever's happening around this case, right? I mean, you start looking at people's contracts, you start looking at how compensation packages work. You start digging long enough, you might find record label percentages of ownership in streaming services, how many times they're doing deals essentially with themselves. This has been a very murky business. It's an industry started by literal gangsters, right? The music business is not a clean space at all. And so when you start discovering, you start digging for information, it raises more questions, just generally speaking. And so UMG, do they have a temperament to deal with that? Would they put themselves in a position where they're handing over all kinds of different information about their business practices? I can't see it happening. Now, one of the things I do find really interesting, and we'll look at this next part here, is that just because there's the discovery process can go forward, UMG can still argue in court. They can still object to things Drake's legal team is requesting in that discovery, right? So this case really just got a lot more complicated. If Drake's team, requests discovery on, the past 5 years of contracts with rappers, and UMG is like, no, that's not relevant. There could be all kinds of battles in court over each of these. So potentially this case could go on a lot longer than where we are right now. Now, this was very interesting today. Check this out. This is from Inner City Press on Twitter. Inner City Press actually live tweeted the hearing this morning. So let's take a look at what Inner City Press tweeted here. It says, okay, heading to Drake versus UMG case about Kendrick Lamar's diss track, Not Like Us. Will Judge Vargas grant UMG's motion to dismiss to stay discovery? Inner City Press on the case aims to live tweet thread below. The lawyers are in place, 3 for Drake at the front table, 3 for UMG at the back. All rise, Judge Vargas. I have a pending motion to stay discovery. Mr. Ransom, it's your motion. Ransom of Sidley for UMG. There has been a change. Plaintiff has essentially withdrawn his first complaint, saying there'll be a second one, so no discovery. Judge, I don't generally stay discovery. Why should I? UMG's Ransom. That Drake is amending speaks to the merits of our motion to dismiss. This song came out in May 2024. He didn't file until January 2025. There is no urgency. Judge, it's your burden. That means they're the ones that have to prove why the judge should stay discovery. They have the burden of proof. UMG's Ransom. They could have filed their amended complaint weeks ago. We would be burdened. They seek every document showing marketing for Kendrick Lamar. That's extraordinary. They seek compensation at Interscope. It's crazy. This stuff is straight nuts. This is a rap battle. A rap battle. And Drake is going to find a way to come away with something. He's leaving here with something. That's what Drake is saying. Every document showing marketing for Kendrick Lamar. Compensation at Interscope. Does UMG have the temperament to deal with this process? Is it easier to find an opportunity to just settle? Pay him $1 billion, pay him $4 billion, just get him out of here. Is there stuff, and I tend to believe this is the case, are there business practices in the music industry that if they came to light, people would go to jail? I tend to believe that's the case. I tend to believe that this would be a lot easier for UMG to just settle. But this keeps going. I'm speaking from the perspective of what UMG is essentially saying in my mind when I read this. They could have filed their amendment complaint weeks ago. We would be burdened. They seek every document showing marketing for Kendrick Lamar. That's extraordinary. They seek compensation at Interscope. UMG's lawyer. Defamation cases are different. There is the First Amendment. Discovery should be stayed. Judge, Mr. Gottlieb, that's Drake's lawyer. Drake's Gottlieb. The test is if the defendant has shown the complaint is unmeritorious, facially without merit. Drake's lawyer. The motion to dismiss in this case is entirely an attack on the factual allegations in the complaint. UMG says no listener would believe the allegations in the song, so there are factual disputes, so discovery should not be stayed. Now, I'm not sure if this is a paraphrase from Inner City Press. He's live tweeting it. He seems like he's writing pretty fast, right? But they were arguing that no reasonable listener, which is different than no listener, like no reasonable person who understands the context of this would think that the things that Kendrick's saying about Drake are true. Now, there's another article we're going to take a look at after this. There's a bunch of people, lawyers, talking about could Drake actually win this. We'll take a look at that after this. And there's some interesting takes. There's some really interesting takes. But back to how the hearing went today. Drake's lawyer. They have sent us a Rule 11 letter about only 5 paragraphs of our lengthy complaint and the use of streaming farms. We have exchanged letters. We intend to withdraw those, but it's a tiny portion of our complaint. Now, that part is really significant. That is really significant, right? I mean, they settled with, not settled, but they're going to amend their complaint essentially to take out the botting claims, the streaming farms, what they're talking about. They're going to take that out, right? So that's the whole argument that you hear from people incredulous about the success of Not Like Us. They have been arguing that Kendrick and his team used bots to artificially manufacture the success of the song. That was challenged in the Rule 11 letter. Drake's team is taking that out of their filing because they're going to refile. There were some points after the motion to dismiss that they've decided they're going to amend their initial complaint. But they're taking that out. They're taking that out, right? So that whole argument, that Drake botted Not Like Us is not a part of this suit anymore. So they essentially have to, so now that argument definitely doesn't hold up. I don't think it held up ever, but now Drake's lawyers are saying it doesn't hold up. 1 second applause. All right, so that's a big part of this. But again, ultimately what they're doing is they're going to amend their complaint. Drake's lawyer, their motion cites previous songs, so we intend to amend to address those. And the Super Bowl halftime show, it was more defamation. They continued to promote the song after they'd been informed about the harm, right? So when they refile, it looks like they're going to address the previous songs in this battle, because that was another significant part of UMG's motion to dismiss. Drake's initial complaint looked at Not Like Us in a vacuum. They didn't talk about any other songs that happened in this battle. We covered that here on this channel too. Take a look. I'll put a link in the description. Check it out if you missed it. But they didn't talk about Euphoria. They didn't talk about Family Matters. They didn't talk about Tailor-Made Freestyle. They didn't talk about push-ups. They didn't talk about the fact that this is a rap battle. They just said this song is anti-Semitic and people are showing up at Drake's house now, and now his life is ruined. Can't tell from the Nokia video, by the way. Nevertheless, UMG spent a lot of time talking about all these songs because they rebutted the defamation claims by saying, well, you know, on Tailor-Made Freestyle, Drake is the one who said that, hey, talk about how I like young girls. So he actually said that first. You know, so if there's defamation, if you're saying that certified PDF is defamation, well, Drake is the one that says that he does that. Oh, you want to talk about violence at your house? Well, Drake is up here slitting throats with a razor. That's what he's doing. Oh, you want to talk about making things up? Well, Drake's over here saying Kendrick abused his wife and his best friend's actually the father of his child. They added context to it. Now Drake's team is looking at amending the motion to also include the previous songs. Keep that in mind. Keep that in mind, though, because this article that we're going to look at next after this, really interesting on that point. So, Drake's lawyer. My friend claims our requests are overboard, but it's no different than any other corporate or institutional defendant. An NFL case had 40 defendants. Here it is. Here, it's a single defendant, request generally limited to 1 year. Right. Okay, so this is, again, request for, you know, Kendrick's contract, all the marketing correspondence, compensation packages for Interscope executives, UMG executives, all that stuff. Drake's motion to stay was based on the fact that would add undue burden for this case, right? If they started discovery before there was a decision on whether or not the case itself was going to be dismissed, if they start discovery now, it's an undue burden, right? And honestly, from what I read, it was actually a very small part of the UMG filing, and perhaps that's a misstep. They didn't spend enough time talking about the details of why that would be burdened. I don't have the legal strategy in front of me. Perhaps their strategy was to be very thin on that part, hoping that the overall circumstances, the color, the context that they framed this battle within would be enough to convince the judge to dismiss this because, yo, this dude is suing over rap battle. He's suing over a rap battle, judge. Are you serious? We're going to start allowing people to sue over rap battles, judge? Perhaps they thought that was going to be enough to convince the judge to just dismiss this right now or stay discovery right now. But they did not focus on what the actual burden would be to UMG to provide this information. It was a very small portion, which Drake's team rebutted. So that's where this comes from. They're saying the NFL had 40 there's NFL cases that had 40 defendants, and they still did discoveries, a bunch of stuff. This one is just one guy. Okay, it was one company. They can figure it out. That's what Drake's team's arguing right here. Drake's lawyer, we'd agreed to this court's standard protective order. Defamation cases have an actual malice standard, and we've far more than met that. But there's no separate discovery rule in defamation cases. They are not a newspaper. They sell music. I'll read that one more time. We agreed to this court's standard protective order. Defamation cases have an actual malice standard, and we've we far more than met that. But there's no separate discovery rule in defamation cases. They are not a newspaper. They sell music. Now, here's where the judge talks. Here's the judge. You say there are 16 requests for production pending. Any third-party discovery? Drake's lawyer. We've served 3 third-party subpoenas, and we are trying to serve a 4th. They will go forward in discovery if discovery is not stayed. So again, they just referenced this NFL case that had 40 defendants, and they're saying, hey, we've only served 4 people, right? So that's kind of how this conversation is going. Drake's lawyer, we intend to depose a number of people. Judge, you propose fact discovery closing in October? Drake's lawyer, it's fast, but we're facing harm and want to move forward. So if I'm reading this right, it looks like they're proposing discovery would be over in October. So that would be basically another 6 months that we have to wait to see if this moves forward, if it's not dismissed, because there's a possibility this case could still be dismissed, right? But if it moves forward, it'll be another 6 months just of discovery. Judge, in terms of the motion to dismiss schedule, you'll amend when? Drake's lawyer, April 16th. So that's another date to look out for. April 16th, by April 16th, we'll take a look at Drake's amended complaint against UMG. Judge Vargas, then they move to dismiss by when? UMG's lawyer. We'll have 3 weeks, then 14 for opposition, 7 days for reply. Right, so I guess it's 14 days, 7 days reply, perhaps. Judge Vargas, I'm going to take a break, then rule. We'll continue. I'm going to take a break, then rule. So he takes a break. Judge has to take a break and process all this. All right, so judge comes back. All rise. That was my little judge impression. 1 second applause. All right, all rise. Judge Vargas, Drake is a top charting rap artist. He claims Not Like Us is intended to convey the message that plaintiff is a PDF. There are pleadings from April to May 28th. UMG argues discovery is premature and sought to adjourn. Judge Vargas, discovery is not usually stayed, cases cited, but I have considerable discretion to do it if I find good cause, an unmeritorious claim, burden, and unfair prejudice. UMG seeks to dismiss all 3 counts. I cannot assess the strength, and then it cuts off. So I'm not sure how the judge finished that sentence. So here's Inner City Press again. I cannot find on that basis that a stay of discovery is warranted. Here, there's only one defendant, which weighs against staying discovery. UMG can object to individual requests. The motion to stay is denied. So that's how that went. So basically what they're saying is there's only one defendant. It's not as complicated as they might make it seem. Truthfully, in UMG's filing, they didn't spend a lot of time describing how and why all that would have been burdensome. Like, I'm reading this book right now. I think it's called Revenge of the Tipping Point by Malcolm Gladwell. 1 second pause to Malcolm Gladwell. And they go into some of the lower court cases that led to the removal of affirmative action. And it really looks at how college admissions practices. And what he's breaking down is the rule of the magic third, right? Which is part of a broader section of the book that really looks at social engineering. Here's the point of this. In this book, it points out how in the 1920s, Columbia University, the Ivy League school, was just a meritocracy, right? Whoever did the best on the tests is, whoever had the highest scores were the ones who got into the school, right? Then they looked up in the 1920s, and 40% of the student body was Jewish. So 40% of Columbia became Jewish based on how they did that practice. And the president of the college ran into a problem because once they got to the point where there's too many Jewish people, then all the Gentiles stopped wanting to go there. They stopped wanting to go there because the school was too Jewish. So non-Jewish people didn't want to go to Columbia anymore, right? And the president of Harvard at that point in time looked at that and says, yo, how many Jewish people we got? And we're like, oh, shoot, we got 25%. We're getting close to that tipping point. Because their argument, the way they looked at it was if you have too many Jews, then you don't have non-Jews who want to go to school with Jewish people, particularly at that point in time. You didn't have non-Jews who wanted to go to school with those people. And then if you just kept going at that point, then Jewish people wouldn't want to go to that school either, and then you have no school, right? So this is where the idea of having a balanced student body or trying to find the right numbers of different populations for a student body really crept into Ivy League education. The point is this. The president of Harvard looked at that and they said, oh my gosh, we gotta start monitoring how many people we keep of different populations. And so basically throughout the history of Harvard and spread to the rest of Ivy League schools, and I'd argue to some degree most of the colleges in this country, this is where distribution percentages of certain populations came from in colleges. So if you go from like 1930 to almost present day at Harvard, you had 60% white people, 10% or 3 to 5% black people, or 10% black people, 10% Latin people, 8% Asian, or 13% Asian, whatever it was. The numbers were just static, right? Because they felt like that was the right balance. They felt like that was the actual right balance, right? But you can't report on these things. So what happened in the court, the court used a Texas case, and Texas got all the way to the Supreme Court when it came to affirmative action. And the Supreme Court says, you guys are basing this off of a critical mass analysis, which is essentially how they describe what Harvard and these colleges were doing. And Texas was like, yeah. He's like, okay, so what is the critical mass? How do we know that you have, what is that number? What is the critical mass of a certain population that lets you know that you are giving opportunities to people of different backgrounds at these colleges? And Texas just talked all the way around it. Texas didn't want to say what the critical mass number was. I mean, they had some of the best lawyers in the country. They're basically taking this trial all the way to the Supreme Court to prove that they're not discriminating against Asian people. So the justices asked them, multiple ways, asked them, well, what's the critical mass? What's the number? If you're saying you have the right number, you're within critical mass, what is the number that you have and what's critical mass? They didn't want to say it. And part of the reason they didn't want to say it is because the number that they had versus the critical mass was wildly different, right? If you look at the rule of thirds, if critical mass says 10% of the population needs to be black or 13% Asian or 9% Latin or whatever, so that you have a balance, based on Harvard's approach to it. If critical mass is, if those were the critical mass numbers, well, Texas only had like 4% black people. So they're way below. They're actually way below. Right, so if they said in court that they were at 4%, but critical mass is 13%, now they're raising questions about Texas's admissions process. Why the hell is Texas? Actually, Texas is more prejudiced than it looks like. The point is, once certain things get on record, they're on record. They're on record, right? And so the judge is asking, why would this be so burdensome to UMG to share this information? And in their motion to dismiss, UMG said it'd be too burdensome, it's just too much work. But they don't really explain why. They don't go into detail as to why that's too much work. How much work is that actually? What is that process? They don't outline that. They outlined everything else really well in the battle. And then, from my point of view, it looked like they hoped that would be the tipping point for the judge to just go ahead and dismiss, and that we could just stop discovery. But they didn't spend that much time on that. And here's what Judge Vargas says again. I cannot find on that basis that a stay of discovery is warranted. Here there is only one defendant, which weighs against staying discovery. You guys didn't break down why this is so difficult. You didn't tell me. You just said it's too much burden, it's too burdensome, and hoped everything else would carry the day. It didn't carry the day. A lot of times when you get into the courtroom, these institutions, that's when they shut up. That's when they clam up, because they don't want certain things on record. Because once certain things go on record, now the entire process, the entire enterprise, the entire matrix that they've built has all kinds of scrutiny on it from all kinds of places. And now the judge says, hey, we can start discovery. We'll have to see how much of an interest UMG continues to have in this. But this is a big win for Drake. Now, here's the last couple of things that Inner City Press mentions here. It says, Judge Vargas, I'll set an argument on the motion to dismiss for June 30th. So that's another date. At 2 p.m., 6 months for discovery seems aggressive. If 56 people were disclosed and might be deposed, So confer and file a new proposal. Okay, so they're going to have a new proposal for that. But now the new date is June 30th. June 30th is the new date to see if this case will be dismissed. April 16th is the date we can expect a refiling from Drake's team. And so this continues to rock on. But this is a good day for Team Drake and for the OVO community, you know, at least from a court standpoint. Now, it's an awful day for hip-hop. It's an awful day if you like, you know, First Amendment rights of artists and musicians. This is a terrible day. And this next piece right here really looks at it. So this is a Rolling Stone piece published yesterday by Nancy Dillon. Drake is suing his label over Not Like Us. Does he stand a chance, right? They spend the first part of this really outlining what we've heard before. But this is the part where I think it gets interesting. So they talked to a handful of different lawyers in music over the years to really look at this. And most of them feel like Drake really doesn't have a chance. This is crazy. But there's a couple in here. Well, there's one in here that makes a couple of really good points. So I'll read you the perspectives of these because I think it adds context to what we just saw. Experts tell Rolling Stone that Drake's chances of prevailing appear limited, though he might, just maybe, have a shot of reaching a jury. Either way, the 91-page lawsuit clearly has a dual role as a public relations gambit and vehicle to save face after Drake lost his 9-track rap battle with Lamar last May. One expert says it could backfire spectacularly. This feels like it's all about vanity, and he's willing to take an entire genre down with him because he lost. University of Richmond professor Eric Nielsen, co-author of the book Rap on Trial, about the use of hip-hop lyrics as criminal evidence, says, "It's sad. I really do think he's tarnishing his legacy." According to UMG, no reasonable listener truly believes Drake is a certified PDF, as Lamar's song states. In his dismissal filing, UMG reminded Drake that he also used his perch under UMG umbrella to accuse Lamar of engaging in despicable behavior, including domestic violence. But Drake is hardly the first to claim song lyrics can be defamatory. This is really interesting because this talks about a bunch of other precedents that weren't listed in the UMG filings. Record producer Armin Boladian previously sued funk legend George Clinton over lyrics that branded Boladian a disgrace to the species. In a 2005 ruling, the U.S. Court of Appeals for the Sixth Circuit tossed the case for good, calling a verse a puerile taunt that, for better or worse, is typical in rap music. 1 second applause. Lindsay Lohan later sued Pitbull over his 2011 song, Give Me Everything. A federal court sided with Pitbull, saying the Supreme Court has made clear that music as a form of expression and communication is protected under the First Amendment. 1 second applause. One of the most famous cases in this area involved Eminem being sued by former classmate D'Angelo Bailey over the 1999 song Brain Damage. This fat kid named D'Angelo Bailey. That's a great song. 1 second applause. I forgot about this completely. Which depicted Bailey as a violent bully. The Michigan judge who terminated that case included a ridiculous rap in her 2003 ruling, rhyming that the lyrics are stories no one would take as fact. They're an exaggeration of a childish act. That judge dropped bars to stand up for the First Amendment. 1 second applause. Not a bad rhyme. If history is any guide, Drake is not favored to win, with several experts agreeing that he has a high hurdle to overcome. They say music, and battle rap in particular, is an art form where insults are clear rhetorical hyperbole protected by the First Amendment. As to enumerate the strengths and weaknesses of Drake's case, they weighed on both sides. Here's the problems with Drake's complaint, right, per these lawyers. When UMG filed its dismissal motion last month, it blasted Drake as a sore loser. The company said Drake not only encouraged his public feud with Lamar, but even goaded him to respond when he thought his nemesis was taking too long. In back-to-back songs released the same day last April, Drake rapped that he was heating up the rivalry and wanted to know what the F is taking so long, we waiting for you. In his follow-up song, Family Matters, released May 3rd, 2024, Drake accused Lamar of beating and otherwise disrespecting his fiancée. Drake also claimed one of Lamar's kids was actually sired by Lamar's business partner.
Tomato.
Experts say such context can't be ignored, meaning Drake was clearly involved in a two-way exchange of diss tracks with Lamar. Context matters a whole lot in libel lawsuits. Where something was said, the words around it, the medium, says attorney Pete Kennedy, an expert in libel law at the Texas firm Graves, Doherty, Huron, and Moody, who in 1997 successfully defended the late Tupac Shakur and Interscope in a case involving claims Shakur's lyrics inspired violence against law enforcement. I remember that case. This is actually a good source for this article. For Drake to succeed as a public figure, suing for defamation, he's required to show that a knowingly false statement was communicated as a statement of fact. Kennedy said this could be a real challenge because art and its penchant for hyperbole is protected by the First Amendment. Some of the hardest cases to make are when something is contained in a piece of artwork. Art is generally not meant to be taken literally. It's quite a stretch to claim something that's in a song that falls within a genre known for people exchanging insults is a statement of fact. He said Drake might also face an even higher standard under the doctrine of invited libel. This is really interesting because he prodded Lamar's response. Kennedy likened the nudging to someone giving a former boss a job reference and then complaining when the ex-boss says something negative. Dog, I hit you up as a reference. You weren't supposed to say nothing negative. Now we got beef. Dog, you shouldn't ask me in the first place, or you should have asked me what I would have said. 1 second pause to that, that metaphor, though. That's a good one. And while Drake claims in his lawsuit that millions of people who listen to Not Like Us and watch the video actually believe the PDF allegations, Kennedy says the court will almost certainly do the homework necessary to determine what a reasonable rap fan would believe. Just because some people might think something that's obviously not true is true, that doesn't mean you get to a jury, Kennedy explains. There are people who think that the onion is true because they don't know what the onion is. The judge will look at this and ask, could a reasonable reader who reads the whole thing and is relatively intelligent spot and understand that this is parody or hyperbole? Of course, according to Nielsen, rap battles and diss tracks are famous for being as audacious and inflammatory as possible in an attempt to get the other side to concede defeat. He said such back and forth battles are akin to the dozens, a game popularized in African-American communities where nothing is off limits and people who fail to understand the rules might take offense. It's hard to watch what Drake is doing right now. He's embarrassing himself. Drake knows the rules. He's been in some pretty tough battles. He's not adhering to the rules now because he lost. He's not adhering to the rules now because he lost. He got his ass handed to him and he's acting like a petulant child. Nielsen said rap fans know not to take lyrics literally. I understand being called a PDF is disgusting. It's one of the most insulting things you can imagine. But what has always made rap so successful and popular is that it pushes the limits rhetorically. Kennedy, meanwhile, also took aim at Drake's claim that UMG had an incentive to brand him a PDF because the company is set to renegotiate his contract this year. In his lawsuit, Drake and his lawyers allege UMG was looking to gain leverage to force Drake to sign a new deal on terms more favorable to UMG. That's a ludicrous theory, Kennedy says. No record company will want to suggest one of its artists is a PDF, period. Nobody wants to affiliate themselves with a PDF. End of story. I don't think a judge will give that a second thought. I mean, you get Drake as damaged goods. Would UMG want to do that? Now you're out here selling a PDF. Interesting argument, legal theory. Now, this is the part that I think is really interesting because I don't think a lot of people have focused on this part of the potential argument. Okay. This is the strengths in Drake's case. One lawyer familiar with musicians suing over rivals' lyrics had a different take. He said while he believes Drake has a high burden and high bar to succeed with his lawsuit, there are some arguments to be made. Warren Fitzgerald Muhammad represented former Destiny's Child member LaToya Luckett and Latavia Robertson when they sued Beyonce, among others, for an allegedly libelous line in the hit song Survivor. They said the disputed line, "You thought I wouldn't sell without you, sold 9 million," was out of bounds after the parties settled a prior contract dispute and signed a non-disparagement clause. Luckett and Roberson's case was dismissed on procedural grounds and abandoned, but Fitzgerald Muhammad said he still believes song lyrics can be defamatory. In Drake's case specifically, he believes Drake could be helped, this is it, by the line in Lamar's song Euphoria, released April 30th, 2024, that states, "Don't tell no lie about me, and I won't tell truths about you." All right, that is, if we're looking at the things that happened in the battle, and UMG has spent, how many pages was that? Was that a 40-page, 30-something page motion? Arguing that it was a rap battle, no reasonable person believes this stuff to be true, right? Well, potentially, I guess what they're saying is the legal rebuttal, or whenever Drake's team refiles, the line at the end of, or at least the opening refrain in Euphoria, "Don't tell no lies about me and I won't tell truths about you," could be of note, could be helpful and beneficial to Drake. He continues, "He's advancing the notion that he's about to disclose some actual facts," the lawyer tells Rolling Stone, referring to Lamar. "On his face, this is a difficult case, but Drake can stitch things together to say that what was being alleged was meant as a statement of fact, not just opinion." I mean, and that's part of, we talked about this on Culture United. The overall banner of hip hop is people talking about how they're keeping it real. Now, we know people don't keep it real, right? And so, but there is that element that sticks to rappers in a way it doesn't artists in other genres, and it doesn't with actors, for example. So if Drake can lean into that, who knows how the judge will look at this. Jonathan Grunberg has also experience with defamation claims in a celebrity case. He explained he helped represent the cave spelunker who sued Elon Musk and made it to trial in Los Angeles. A jury ultimately let Musk off the hook, finding he wasn't being literal when he called plaintiff Vernon Unsworth a pedo guy in a tweet. But the case got much further than expected. Grunberg says Drake's lawsuit could similarly find its way to a jury with a specific approach seeking to use Texas state law, even though the lawsuit was filed in federal court in New York. Drake is a citizen of Texas, so he could argue that the law of his home state of Texas should apply under New York's significant relationship test, Grunberg says. That test could find that Texas' connection to the party's dispute is stronger than New York's. So this article is giving all kinds of ways that potentially Drake's team could maneuver around this big hurdle that they have to cross here. It goes in. New York provides a far greater protections than most other states for defendants in defamation cases based on statements of opinion, Grunberg explains. Texas law follows the U.S. Supreme Court's approach on the issue of whether statements of opinion are protected, an approach that is far more favorable to a plaintiff in a defamation case than New York law. Under Texas law, Drake has a strong argument that a jury, not the judge, should decide if Kendrick is actually accusing Drake of being a PDF. Including because some listeners may reasonably understand that Kendrick is literally accusing Drake of being a PDF. The lawyer said the notion that rap lyrics can't communicate literal and factual accusations simply because they're part of a rap song is debatable. This brings to mind the controversy over prosecutors using rap lyrics against defendants in criminal cases. A tactic that assumes rappers mean what they say in their music, Grunberg says. And this is where I really have a problem. This is another reason I have a problem with this whole endeavor for Drake. It's selfish, self-serving, and is attacking what's generally been legal precedent that's favorable for artistic expression. And if he wins this, then all of that is in dispute. Now, if artists got to curb what they say within a label system, or generally speaking, that's one thing. But if people start getting convicted, that's another thing. And this is what this case brings to mind. This brings to mind the controversy over prosecutors using rap lyrics against defendants in criminal cases, a tactic that assumes rappers mean what they say in their music. Drake himself has advocated against this tactic, but he now must argue that rap lyrics are understood as statements of fact, as opposed to mere non-literal creative expression. Ultimately, the fact that prosecutors have secured convictions relying in part on rap lyrics demonstrates that rap lyrics are capable of communicating factual statements that can be the basis for a defamation claim. Nielsen says that if Drake's lawsuit is successful, it could redefine the rap genre. I'm concerned because this could be a terrific gift for the police and prosecutors if he's successful. I'm concerned because this could be a terrific gift for the police and prosecutors if he's successful. They will lean on the logic of this lawsuit to justify using lyrics in criminal cases. This could have a real chilling effect on the industry. There's so much more going on here so much more at stake than just a rap battle at this point. You know, Drake is literally out here willing to make it harder for people to fight situations like this in court. This has a potential criminal effect per these lawyers in this article. A chilling effect on the industry. And he don't care. He said he gonna go home with something if I have to wreck everything that has given him so much, that has given his family so much, that has blessed so many people around him and him himself, that'll give his kids and his family in the future so much. He will destroy all of that because he can't handle losing. Let me know what you think about all of this, but this is the update to what's happening with Drake's case, his defamation lawsuit against UMG. We will be following this as it goes forward. Key dates to look out for are April 16th and then another one in June 30th. So keep it locked right here. Thank you to everyone who supports this channel. My name is Justin Hunt. Like and subscribe to the channel. Follow at The Company Man on everything. Follow the Justin Hunt podcast wherever you listen to podcasts. It's all happening.
Justin Hunt is here, it's all happening. Justin Hunt is here, it's all happening. The mathematical breakdown of this mighty game of rap we in. It's boom bapping. Systematical culture views, it's radical, it's all happening. Shaking hands and dapping it. Life through the lens of hip hop, from trip hop to yes, dog. You don't stop, you don't stop. Justin Hunt is here, it's all happening. It's all happening, yes, it's all happening.